JustinBaldoni's team has issued a response in opposition to dismiss the New York Times.
How the New York Times actively vouched for the veracity of its false narrative.
We actually want all evidence to come out that's proper and appropriate evidence.
BlakeLively's lawyer has resigned following a significant update from Brian Freedman in their lawsuit, and frankly, it's no surprise. From the outset, Meryl Conant appeared overwhelmed, trying to defend a case built on nothing but speculation. Let's be real, only a master illusionist could have...
I looked through every document, every email, every text message.
With this development, BlakeLively's legal team is in complete disarray. Honestly, it was only a matter of time. No one can blame her...
They hired, meaning the Wayfair parties, hired a crisis PR manager who orchestrated a smear campaign against Lively.
Maybe they thought a little PR spin could change the game, but the courtroom doesn't care about Instagram posts. It's all about facts.
It wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
As if that wasn't enough, Conant was under immense pressure from every direction. Representing Blake, a high-profile client determined to win at all costs, despite the lack of evidence, was no easy task.
Yeah, and again, at the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads of theories and...
Hold that thought.
Here we go. Generally working to change the narrative. So it's impossible to know how much they planted and how much of it originated organically. Well, wait a minute.
Now, you might wonder, if the case was this weak, why didn't Blake see it from the start? Well, remember when the New York Times backed her claims? At that moment, it seemed like a win-win for her team. When, in December 2024, the New York Times published an article and video supporting her accusations against JustinBaldoni and Wayfair Studios, her case appeared bulletproof.
This suit against the New York Times is hard.
After all, if the New York Times, an institution that has shaped history, backs something, it has to be true, right? Interview 14.
Reynolds and Lively wanted Wayfair to issue a statement taking the blame for Lively's bad press.
This latest document didn't just challenge Blake's case, it dismantled it entirely. Sexual harassment claims. Non-existent. Body shaming.
Baldoni's team drops a massive $400 million suit on Blake and a lawsuit against the New York Times. Then they publish 170 pages of perfectly documented texts and emails between all the parties that basically show Blake to be the aggressor. Here's the proof.
In fact, every allegation Blake made was systematically debunked. As the case unraveled, it became clear she was trying to play the victim. No evidence, just a string of accusations. The more Conant fought, the more she realized she was
You're making a factual assertion that these people did something, seizing on it and amplifying it.
For a brief moment, it looked like Blake had secured the ultimate endorsement. The article, titled "We Can Bury Anyone," Inside a Hollywood Smear Machine, was supposed to be her golden ticket, a strategic PR move to make her claim seem as solid as a courtroom verdict.
So you might as well just amend the complaint and clean it up now. So it wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
As if that wasn't enough, Freedman introduced another major legal argument: jurisdiction. And in this lawsuit, jurisdiction is a game changer.
That's the whole point of a lawsuit, is you just start with allegations, and allegations are not evidence. They're just statements of fact that help establish this is the claim that I'm bringing.
Initially, Blake's case seemed formidable. Allegations of sexual harassment, body shaming, and breastfeeding discrimination had all the right elements for public sympathy. But in reality, there wasn't a shred of evidence to substantiate it.
Here is the clip in question. Now, this video,
filed on Friday.
Thank you to Citizen Journalist for putting it on easily accessible. This was part of the article.
According to Freedman, the New York Times wasn't just reporting on Blake's allegations. They were presenting them as indisputable facts, blurring the line between journalism and advocacy.
They decided not to run it for fear of defamation, I'm sure, for fear of you and defamation. So they didn't run it, but some of these TikTokers have done it.
By doing so, the New York Times lost its fair report privilege protection, exposing itself to potential legal action. Freedman argued that the Times wasn't just guilty of biased reporting, but actively participated in tarnishing Wayfair's reputation.
He mocked Baldoni in the process. He said It's an effed up bad situation with what Baldoni, whatever his name is doing.
They presented Lively's version of events as verified truth, a serious legal misstep. Media outlets cannot portray unverified claims as facts.
If they would have said, Blake alleges that, or according to Blake, blah, 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 this happened, they'd be protected. But they said, and her title is investigative journalist. So she's investigative journalist for the New York Times. So that is implying that she's done an investigation. She's actually looked in this. We can trust her.
It's one thing to report someone's allegations. It's another to present them as established truth without proof. The line between journalism and advocacy became dangerously blurred.
The New York Times have looked into it, and this is what really happened. So now they're stating as a fact, not as an opinion, that this happened, and that's how they're going to get into trouble.
It gets even more damning. The timing of the Times publication was highly suspect. Freedman highlighted that the article was rushed out during the holidays, giving the Wayfair parties almost no time to respond.
It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
It seemed deliberately timed to maximize impact, conveniently aligning with Blake's PR strategy.
If they're supposed to be the bastion of journalism, right? But, if they had just said it's the opinion, would this have mattered? Will this factor in the fact that they did seemingly have this for months due to the metadata and things that we're seeing?
According to Freedman, this wasn't just bad journalism, it was bad faith. The New York Times appeared committed to Blake's narrative from the outset.
And so now they're saying like, hey, we tried to fact check. We gave you the opportunity. Oh, you didn't respond. Oh, if you would have responded, we would have maybe thought of things differently. But hey, we just went with what we had, so we can't be sued. So this is what they're doing.
The fact that the story was finalized before the Wayfair parties were even contacted, that alone was damning. It suggested the Times wasn't interested in the full truth, only in pushing a specific.
So here's why he's suing them. It's super creative. They said, evening of December 20th, hey, Justin, here's all this horrible stuff we're going to print about you. You have until tomorrow at noon. We'd love to hear your response. He engages with them. He says, okay.
Freedman didn't just challenge the Times on its timing. He called out its entire ethical approach. This wasn't an unbiased report. It was a one-sided endorsement.
And New York Times prints a story prior to noon with the partial information. And my guess is they were worried another outlet was going to hit this story.
Rather than neutrally presenting both sides, the Times appeared to have already chosen a winner, turning what should have been a fair report into an advocacy piece.
You're talking about the Wayfair parties over here, and it to me makes it sound like the Wayfair parties did that. And again, if that's the case, if you think that that happened, investigate it. Do a series of articles. Let's see it.
For Blake, what once seemed like a powerful media endorsement quickly became a liability. She and her team likely didn't anticipate that the Times' backing would expose her case to further scrutiny.
It's not unlikely. I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
Instead of strengthening Blake's case, the Times' involvement gave Baldoni's team the perfect opportunity to challenge the credibility of her entire narrative.
You guys were complicit here. You guys were involved in this every step of the way.
Defending a case that's collapsing due to a lack of solid evidence is like trying to extinguish a fire with gasoline. The moment Brian Freedman dropped his bombshell update, the case went into free fall.
I mean, the arguments were really strong, so that wouldn't surprise me either.
All right. Whew, that was a marathon.
Freedman's strategy: move the case to California, where defamation laws are more favorable for his clients.
A campaign to tarnish Lively after she alleged that JustinBaldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct while shooting the film.
Freedman accused the Times of violating fair report privilege, a legal protection allowing media outlets to report on legal matters without legal repercussions, as they didn't just cover the case but actively shaped its narrative.
And that's what the New York Times is coming back and saying, look, we're not BlakeLively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfair for.
Here's the kicker. The Times didn't simply report Lively's claims, they framed them as truth. Instead of saying, Blake alleges this happened.
But what Justin is saying is that California's substantive law should apply on this placing somebody in a false light.
With California's stronger defamation protections, Freedman isn't just aiming to win, he's making a statement.
Recognizes a claim for damages or for money for placing somebody in a false light. New York doesn't have that same law. What Justin, I think, is correctly saying is that, hey, I'm a California guy.
Freedman also pointed out how the Times rushed its article, giving Wayfair almost no time to respond, a classic bad faith move.
All these other people in California, you, New York Times, based in New York, knew that publishing this story would impact me and others in California. So you reached out and touched us in California, so now California law applies.
The timing was no accident, it was strategic, pushing a narrative without allowing a rebuttal. Interview 36. And now, Freedman is taking it even further, arguing actual malice.
So we kind of knew this was coming, didn't we? The collusion argument.
Resigning was likely the smartest move to protect her reputation from sinking along with this crumbling.
And they're arguing that California's tort claims, etc., damages in California are different because make their personal and professional homes, they may make claims in California.
Wayfair's careers were most impacted in California, and Freedman made sure to highlight that.
An intimacy coordinator, and Blake refused to meet with him or denied, said, I don't need to meet with the intimacy coordinator. I'll see you on set. I'm all good. So, then Baldoni is tasked as the director with going to break down what happened when he met with the intimacy coordinator so he could get her up to date on it all.
California is the entertainment industry's battleground, where reputations are most at stake, making it the logical jurisdiction for this case.
There's a lot of factual determinations that need to be made here, not legal determinations. And because there's factual determinations, you got to leave it to the jury. You got to give a jury the property.
Yeah, exactly. And so they're just saying, look, just let the facts decide. And the trier of fact in any case is going to be the jury. Unless it's a bench trial, then it's a judge. But this is not. This is a jury trial.
The more JustinBaldoni's team investigated, the more Blake's accusations began to resemble a poorly crafted script. No messages, no documents, nothing to validate her claims. Every time Blake's legal team thought they had solid footing, it turned into quicksand. And here's the kicker. Blake's PR team played a role in this too. While they framed the fight as one for justice, it was really about maintaining an image. They pressured Conant and the legal team to continue, even when there was zero proof to support Blake's claims.